So let's talk more about those conservation rules. Where you can put your well, if you can get an exception to put your well that someplace that wouldn't normally be allowed under the field rules, and then how much you're allowed to pump each day, your allowables. So to start with, let's talk about those spacing and density rules and some exceptions to those rules. So at times, to protect your right to produce oil and gas, you may be able to get an exception to drill a well that doesn't meet the normal spacing and density rules. So typically there's two kinds of different exception locations that you would get. The first is to prevent drainage to a neighboring well. So that's if you don't want to have your oil and gas drained off to your neighbor's well, and you need to drill a well slightly outside the normal rules of where one should be drilled to prevent that well, that oil from going to your neighbor's well. The other is that you could maybe drill an exception well, one where one would normally not be allowed if it's necessary to prevent waste. And by waste, what we're talking about here is oil and gas left in the ground. So I'll give you sort of an illustration of what both of those might look like. But first, let's talk about a case. Let's talk about this Tentaco case from North Dakota, 1964. It's on page 730 in your book. So this is a field where we have just general north-south 80 units set up. So remember, 80s, we're talking about 80-acre units. So just like in that Larson case where we had 80-acre units, and they're north-south 80s. So imagine that you had two next to each other. They'd look like this. And that wells are usually allowed in the northeast and southwest 40s. So you would have a well here in the northeast and here in the southwest. So that you would have this offsetting wells pattern throughout the entire field. Now the issue here is that Tentaco has leased the west half of one of these, so it has one of these north-south 80s, and it wants a northwest 40 exception well. So imagine that we got another two here, and it would like to drill on the northwest. That normally would not be allowed because normally you have to drill in the northeast or the southwest. Those are your two options. And the reason that they want to do that is because they suspect that the southwest, where they would normally drill a well, is going to be dry. And that's because the neighbor's northeast well, so if you go down here, the neighbor's northeast well right here was totally dry. There was nothing there. It was a dry well. And so they're concerned that if they drill in the normal spot that they would be allowed under the field rules, that won't work. And so they want to use this northwest location. Now, who might be opposed to that? Well, what you'll find is it's the companies that you would imagine would be opposed, which is that there are two companies here that are allowed to drill on the northeast quarter of their quarter section or on the southwest quarter that are very close to this well. And they're concerned that if this exception well is allowed for Tentaco, it's going to take oil from their two wells. Okay, so that's who's opposed to this. Now, one thing I'd like you to note is you have that case Somas in your book on page 737, and that's about plugging old dry wells like this one right here. And what you see in that case is something that maybe you might not think of, but in that case, the big controversy is between the oil company that wants to actually permanently abandon its well and the landowner who wants to leave those wells possible for reopening later. That might be a little surprising. Doesn't the oil company want to produce oil? Doesn't the landowner want its land restored? And the answer is, well, the landowner has the strongest interest in oil production from his or her land. And so for that reason, that landowner wants to keep those wells open. Another thing that you can see from that case in the notes is that generally there are requirements on the oil companies that operate those wells to recover those wells and pay to abandon those old wells. Even if they've actually sold that well, they may still be caught with their old wells with a requirement to plug it. Basically, what that's going to mean is using concrete to make sure that that well is never going to leak to the surrounding land or water, and you cut it off below the surface and restore the surface so that from the surface you wouldn't realize that there had been a well there. Okay, so in this case, the whole fight is about can they have this exception well, and some people say, well, that goes against the field rules and you're just going to take from our good wells, you don't get to drill somewhere else. The little bit complicated thing about this case is Tentaco then ends up leasing the east half as well of this 160-acre section and says, well, couldn't we, other option, let's have an east-west 80 and just give me an exception on the west side. So one way or another, I want to drill that northwest quarter of those two 80-acre sections together, those 160-acre sections. But ultimately, the State Industrial Commission, which is North Dakota's oil and gas regulator, says that they haven't met their burden. And so you note that in each of these states, there's a different name for that oil and gas commission. Sometimes it's called the Oil and Gas Commission, sometimes the Oil and Gas Conservation Commission, like in the Larson case in Wyoming. In Texas, it's the Railroad Commission. In Oklahoma, it's the Corporation Commission. But in this North Dakota case, it's the State Industrial Commission is the regulator that handles oil and gas. And here they say that Tentaco has not met the burden to have an exception well. But we will see some other cases where the company is allowed to drill an exception well, and some of the reasons that might include. So what are the two basic reasons that are described for why you might get an exception well? Well, the first one is if there's an exception to prevent waste. So imagine that we have a unit, and let's imagine this entire unit is 80 acres for this example. And the legal location would be this spot on the east side of that unit. Well, the problem is if the reservoir is everything inside this boundary, this reservoir edge, that legal location wouldn't actually access the oil in the reservoir. And so you might want that well put on the west side in Blackacre in this example. Okay, so that would be a exception to prevent waste. And the reason we say that it's an exception to prevent waste is because if you don't allow this well right there, that oil and gas will be left in the ground. And when we talk about an exception to prevent waste, we're trying to prevent oil and gas from staying in the ground. That would be the worst possible outcome, at least under this theory of conservation law, which is that you get an exception to prevent waste. Another potential exception is imagine that in this case, these are both 40-acre units, and both of them get a well. So Blackacre gets a well in its middle, that's fine, it's able to produce oil and gas. In fact, if you look at the amount that it can drain the entire reservoir, including it goes beyond the reservoir edge, which is on Whiteacre's property. So it can drain all the oil and gas on Whiteacre's property. So here, you don't need an exception to prevent waste because there's going to be no waste. All this oil and gas will be produced. But Whiteacre still may ask for an exception to drill right here on the edge because they would say, well, we need an exception to prevent confiscation. So yeah, all the oil and gas is going to be produced, but the oil and gas that's on my land is going to go to my neighbor's well. And if I have to drill in my normal legal location, then I'm not going to be able to get that oil and gas. It's all going to go to Blackacre. And so I should be allowed an exception well to prevent confiscation. So let me give you an example of this kind of setup where you would want that exception to prevent confiscation. And this is an example that's actually described very briefly on page 735 in your book, but it's from this case, Montana 1965, this Patty case. What happened there is that there was a well drilled on the east side of section 15, and Patty owned the west side of section 14. Now, I don't know if you remember the way you number in a township, but just in case you don't, remember it goes, back and forth. So it goes 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. And recall that the well is drilled on the on the east side of section 15, and Patty owns the west side of section 14. So Patty is concerned that there's going to be drainage of the oil and gas on their land. Now, the well is on the eastern limit for oil. Okay, so the company, which in this case was Sumatra Oil, was drilling on the eastern limit as close to Patty's property as it could. The problem is that they didn't find oil. They found gas. And what we'll see is, remember, gas wells tend to have to be further separated than oil wells. There's a couple reasons for that. One is gas flows more easily than oil. It's a gas, so it's just going to flow a little bit more easily through the rock. And so the theory is, well, you don't want to be right up next to the line. You'll be pulling your neighbor's gas. But secondly, gas is less valuable than oil. And so we don't want quite as many wells, because if you had a ton of if you spent all that money on all these wells next to each other, you're not going to make any money if the gas isn't worth that much. So typically the value of all that gas can only justify fewer wells. And so we demand that those wells be further spaced from each other. And so you're allowed to drill certain distance from the property line if it's oil, but you have to be further back if it's gas. The problem here is Sumatra Oil, the oil company, drilled looking for oil, but they didn't find oil. Instead, they found gas. And so what they did is they said, well, now we're violating the rules. And they went to Montana's Oil and Gas Conservation Commission, similar name as we had in Wyoming, the Oil and Gas Conservation Commission. And they asked, you know what, we were looking for oil, we were at the oil limit, we found gas, we're inside the gas limit, so it wouldn't be legal, but can we go ahead and operate anyway? Because it doesn't make any sense to drill an entire new well, spend all the money on that just to have, when we already have the well drilled here. And the Oil and Gas Conservation gives that to them. Now Patty responds and says, okay, well then I want a well right next to the border, because otherwise they're going to be pulling the gas from my land. But the Oil and Gas Conservation Commission says no. And so this is effectively the setup that we have. Imagine, again, that there's this reservoir edge coming through Patty's property. Sumatra has ended up drilling quite close to Patty's property at a location that would not be legal if they were looking for gas. But they had been looking for oil, they just happened to find gas. Patty has a legal location that for drilling, but the problem is that's outside the reservoir, and so there'd be no recovery there. So Patty requests a spot closer to the reservoir edge, similar to what Sumatra had. And the Oil and Gas Conservation Commission rejects it. And what they say is, look, there's no need for this exception well, because all this oil and gas will be produced anyway. And one thing that we'll see, both in this case and you see in the Larson case, is that sometimes the conservation commissions have a tendency to say, I don't really care who at the end of the day gets this oil and gas. I'm looking out for the overall economy, and I want as few wells as possible and as much oil and gas as possible. So if you're going to get all the oil and gas from one well, why would I authorize another well? That's just a waste of money on drilling another well. But what we see is, like in the Larson case, the Supreme Court of Montana says, not so fast. You're not supposed to just consider the economics and the conservation of producing maximum value from this oil and gas. You're also supposed to be considering what's fair to these individual landowners. And so they're saying you have to consider the equities and correlative rights. So, like in the Larson case, what we find is sometimes if you want to challenge that agency decision, it's going to be hard if you're challenge them based on their expertise. But if you can say they didn't consider a factor that they were supposed to consider, in this case, the equities, then you may be able to overturn their decision, because it's not a question of their technical expertise. It is a question of, did they consider what they were required to consider under the statute? All right, let's look at some more hypotheticals involving this Patty case. So in Patty, suppose that Sumatra's well had been drilled at a routine legal location. Because remember, one of Patty's fairness arguments was, you gave Sumatra an exception, shouldn't we get an exception as well? And I think there it's a much closer case. Because then if Sumatra didn't receive an exception, maybe you say, well, tough luck, the reservoir just doesn't match up with where your well is located. But Sumatra drilled in its normal location and it did get gas. So that's going to be, so they just happen to work out with that pattern, sort of like the Tentaco case. But it's also possible that they would say, no, we don't want Patty's gas being taken, and so therefore you do get to drill that exception well. So I think that's an open question, how that would have been resolved. Another thing you might consider is, what if the facts showed that Patty's off-pattern well, so her well closer to the border, would have substantially drained Sumatra's well? I think that probably doesn't change the facts too much. So I think probably still Patty would have won that case, because if you're both drilling very close to the border within the normal gas boundaries, probably there's going to be some drainage of each other's well. And that's probably, if the Conservation Commission is willing to grant those wells close to the border, they're willing to live with you draining each other's wells to some extent. Finally, you might just consider, what do you think the conservation agency should do in that circumstance? Do you agree with the Montana Supreme Court, or do you agree with the idea that really with the agency, you know what, this is about maximizing oil and gas, we can't be fair to everybody, what's fair is very difficult to say, we're just trying to produce the most oil and gas with the fewest wells? All right. So that's location. Now let's talk about allowables, how much you're allowed to produce every day. So the most common, by far, way of calculating your allowables is based on the amount of acreage that you have in the drilling unit for one well. So think about the Larson example, or think about that Tentaco example. We had these fields where every drilling unit was 80 acres. In those circumstances, every well would have the same amount that it was allowed to produce. But imagine that at the edge of that field, there's some kind of weird shaped sections. Maybe there's a river that cuts off part of it. Maybe there's kind of like a little half section, etc. Usually fields have a lot of normal sized units and a few weird sized ones. And so usually the way that you determine how much each well can pump is that it's proportional to acreage. So if you have a 40-acre unit for some reason, it's going to be able to extract half as much as an 80-acre unit. And if you have a 20-acre unit, it'll be a quarter as much as an 80-acre unit. One way that this comes up a lot is if there's exception locations. So if there's an exception location, and imagine that Patty is allowed to drill closer to that line, they might say, well, look, you only have 10 acres of the reservoir, or only 5 acres of the reservoir. Because the whole reason we allowed you to drill closer to the boundary is because less of that reservoir was on your property, and to get your corner of it, you had to go right up to the edge of your property. If that's the case, you don't get your full 80 acres unit. You just get the 5 acres of the reservoir that you have. Or maybe another reason somebody could get an exception, and we'll see this happens in Texas a lot, is just because all they have is a 10-acre unit. And so if they only have 10 acres to drill for their well, and so then they're only going to get 1/8 of what somebody with 80 acres would have. So the most common way that allowables are calculated is based on acreage, but we'll see that there are more complicated ways of doing it that are sometimes used. So also, allowables sometimes ratchet down over time because often there's a limit on the entire field, how much it can produce, and that could be for several reasons. As we described last time, you might want to limit production from the whole field so you don't dump too much oil on the market all at the same time and lower prices. Historically, that method of controlling overall production was used all the time in the United States to keep oil and gas prices high when the US was the world's dominant oil producer. Nowadays, more commonly, if you have field-wide production limits, they're used because you're trying to preserve reservoir pressure. So you want to preserve that reservoir pressure, and you are limiting how much can be produced at any one time. If you see that reservoir pressure dropping and it's getting harder to pump, you might lower everybody's allowables. So allowables can stay constant for long periods of time, but they can also drop as the conservation agency tries to preserve reservoir pressure. One of the goals here is to prevent interfingering of water. Let me explain sort of what that means. So recall that your basic reservoir is oil and gas that's migrated up from deep in the earth and got caught against a cap rock. And typically it settles out by density. So you get water on the bottom, oil in the middle, and gas on top. Now that gas is pressing down and that water is pressing up, pushing that oil out. Okay, those are gas drive and water drive that are driving your production. Now you got lots of wells going into that oil, they're producing it. You want to preserve that pressure and you want to produce gradually enough that the water and gas can kind of smoothly sandwich that oil and squeeze it out on both sides. If you produce too fast, these things can get mixed up. So the water can interfinger into that oil reservoir, right? This is all happening in rock, right? So the water gets mixed in with that oil. That produces a couple big problems. One is water is much heavier than oil. So once oil gets mixed with water, it's going to be harder to pump to the surface. It doesn't want to come to the surface as much, and that's a problem. The other problem is that once it gets to the surface, you've got all the oil mixed with water. To use the oil, you need to separate it from the water, which can be expensive. Also, the water is expensive to get rid of because a lot of times it contains lots of impurities from deep in the earth, things that you really don't want around. And usually our best way of dealing with it is to just inject it back into the earth. But you have to find a place where that's safe to do, etc. So it's more expensive. So at some point, if too much water gets mixed into the oil, it's just not worth producing anymore. So you're trying to prevent interfingering of water or watering out, which means the well basically is no longer worth producing. You don't want that water mixed into the oil. So here's a case where, and as we'll see, there's so many Pickens cases, but this is Pickens versus Railroad Commission, Texas 1965, page 748. And we'll see that this is a case where the Railroad Commission came up with a little bit more complicated way of determining allowables. So normally we said it's all on acreage, but here the Railroad Commission did it half based on acreage and half based on the volume of the oil reservoir. What does that mean? Well, obviously an oil reservoir has its own shape. So in this case, they kind of said, oh, it's like a pancake, it's thicker in the middle. I think that's a funny thing to say because in my experience, a pancake really shouldn't be that much thicker in the middle, but maybe they make pancakes differently. So you can see that depending on where you are above this reservoir, let's say you're on the left, the right, or the center, you have different thickness of reservoir underneath you. So you have your area, your surface area, which is your acreage, but you multiply that by how many feet it is deep to get your volume. And so the theory would be, well, if I have more acre feet, I have a bigger volume, a thicker part of that pancake underneath my property, then I should get more allowables. The Railroad Commission said, okay, we're going to do half of it the normal way, so everybody will get some allowables based on their acreage, but they'll get half of it based on their acre feet, how much volume. So you'll get more if you're in the middle, but you'll still get some if you're on the edges based on your acreage. Now, Pickens argued that there was no substantial evidence. Remember, that's the typical standard for reviewing that kind of Railroad Commission decision. They said there was no substantial evidence to support the use of acreage alone. They said, look, maybe acreage is fine when you know nothing about the reservoir, but here we know about the reservoir. And so we know that I sit on the thickest part of the reservoir, in that middle, and I should get proportionally more as a result. So we should be using only volume, not acreage. The court ultimately says it's not going to disturb the finding, and let's talk about that a little bit, because it's a great example of how courts are likely to defer to the oil and gas commissions, here the Texas Railroad Commission, when they're dealing with things that are really within their area of expertise. So this was really a battle of the experts. Pickens had experts and the Railroad Commission had experts. So what do those experts say? Well, the plaintiff's expert said high edge pumping, so pumping on those two sides, quicken drainage of the juicier center parts of the reservoir. So in other words, Pickens is saying, look, I'm in the middle, and when they're pumping based on acreage, that means they pump a little bit more of their share, and my oil is going to go to their wells. But the Railroad Commission expert said, no. High edge pumping actually pushes oil towards the center because of water pressure. And what that's going to mean is that those wells on the outside, so imagine that we have, 3 wells, 2 wells on the edge, and then Pickens in the middle. These wells are going to run out of oil pretty soon, and they're going to water out. So yeah, maybe they're producing more than their volumetric share right now, but pretty soon they're going to water out and they won't get anything, whereas Pickens will be happy pumping for decades to come. Okay, now that's obviously a very technical dispute. How does the court handle it? Well, it basically says, look, you're the experts, we're not the experts. So Railroad Commission, if that's what you're telling me, that this is going to lead to fair production to everybody, you consider the right factors, we are not going to disturb that conclusion. So if the Railroad Commission considered the right factors, didn't consider anything it wasn't supposed to, then its expertise is usually going to carry the day. All right, let's look at another example of one of these cases where somebody tried to challenge the allowable determination of the government. This is from Oklahoma in 1947. So the Oklahoma Corporation Commission, remember that's the oil and gas commission in Oklahoma, set a gas-oil ratio of 2,000 cubic feet per barrel. Okay, what does that mean? Why would you set a gas-oil ratio? Aren't those both things you want to produce? Well, yes, but remember, in our reservoir, oil is the most valuable thing. And so sometimes we have a well that we're trying to produce gas, but sometimes it's a field where really what we're trying to produce is that oil. So we're pumping out the oil and that gas is pushing down. So just like we don't want that water mixed with that oil, we don't want to get rid of all that gas either, because that's what's helped push that oil out to all of our wells. And so what the Oklahoma Corporation Commission said is, if you're getting 2,000 cubic feet of gas for every barrel of oil, we're shutting you in, because everybody needs that gas still in the reservoir to push out that oil. So I'm very sorry, but if you're hitting the gas part of this reservoir, we're going to shut you down, because we are prioritizing keeping that gas in there to push out the oil. When that ratio is exceeded, you have to stop producing, even if you haven't met your production allowable for oil yet. So Denver Producing says, wait, that's arbitrary because it's going to cause us to not be able to produce as much oil. And the court basically says, no, the Corporation Commission has made a determination that for the benefit of everybody, it makes more sense to keep this gas in place so that everybody maximizes their oil production. So that agency ruling is going to stand. Another example where if the agency, dots its I's, crosses its T's, makes decisions based on the right factors it was supposed to consider, the courts are usually going to defer to its expertise. They are not petroleum engineers. The courts are not petroleum engineers. They're going to ultimately defer to the agency decision.